So I think I sent over some different things to think about. From my point of view, it's going to be helpful to think about what happens in the court when the court comes online. So at the moment, I think a lot of the events are around opt-out, actually the mechanics of opting out and getting recorded as a representative and how to opt out. So it would be helpful, I think, from my side to focus on when the court comes into being, who's going to be using that and what's that going to look like in terms of litigation strategy, and what are you sort of seeing in terms of, the sense of clients' commentary around people's thoughts towards use of the court and the risk and versus a national proceeding, which possibly is better known. So I think the first area that I wanted to kind of go through was whether people are in or out. So the opt-in, opt-out, but not the mechanics of doing that, more what you're sort of seeing in terms of thought process.
Sure. I think that's quite an astute observation. The focus has been for a long time on the mechanics and the logistics of using the UP system. And of course, the reason it's been delayed is because people are struggling to actually log on to this and get their authentication cards. But the focus is now moving on to litigation strategy. And of course, at our firm, the focus is very much, and has been for a while, on how the court will actually be used from day one and in the case management system in the summarise period. And so in terms of opt-outs, it's an interesting one. It really depends on the client and also on the coverage that they already have in their EP portfolio. Some clients, tech clients in particular, are quite focused in their coverage and really only validate in a couple of key EP jurisdictions. Or if they validate more widely, they very quickly narrow down to just a few, typically Germany, the UK, the Netherlands, Italy, France. Other clients, FCMG, pharma, biotech clients, they'll have much broader coverage, validating and maintaining portfolios, patents in all EP jurisdictions in some instances. And so the decision to opt out in part is informed by that. You can see that for a client with just a handful of EP patents or the national patents in just a handful of countries, perhaps doesn't make sense to be in the UPC. And so an opt-out in that scenario perhaps is a easier decision. Whereas with broader coverage, I think the issues become more complex. There are advantages to staying in the UPC system, centralized revocation and infringement from the patentee perspective, of course, and revocation, to more sophisticated clients who have large portfolios and are validated broadly across EP jurisdictions. There are a number of factors that come into play in deciding whether or not to opt out. The validity strength of the patents is a very important factor. If there is confidence in the validity of a particular patent family, well then that might be a reason to stay in the UPC and not opt out and take advantage of centralized infringement mechanisms that'll be available and the remedies that'll be available in the UPC. Where there is doubt perhaps on the validity, where it hasn't been tested or there hasn't been extensive work done on prior art searching, well then it may be advisable to opt out for the time being, because you can always opt back in, provided that you're not stopped from doing so. There are strategic things that a potential defendant or adverse party might engage in to block an opting back in, and we can discuss those later. Another key factor is really what it is that a patentee wants to do with its portfolio. If it's purely defensive and the patentee is only operating actively in certain jurisdictions, well then they may want to opt out and not be in the UPC. I think at the moment it's fair to say that larger clients are erring on the side of caution and are minded to opt out, but some are considering opting in or remaining in the system. There are advantages also in terms of shaping the direction of the court and the operation of the UPC by staying in the system with a number of patents, and you can be quite fine-grained in how you do this. You can opt out a parent, for example, but leave divisionals in. We're now at a stage in the launch of the UPC where patents or applications that are due to be granted, it's possible to make a request to the EPO to actually delay grant so that they can be granted post-launch of the UPC until you get a UP. And that might be an option for certain divisionals to just test the waters and see how the court will operate. there's still a lot of uncertainty. It's a very exciting development. We're all looking forward to the UPC, but it is completely new. And so I think we will all want to see how it develops, how the rules are actually put into effect, and the practical realities of litigating in the court. So, of course, we're very excited about the imminent launch of the UPC. It's an attractive new forum, but we don't know how it's going to play out. We have a comprehensive set of rules and procedures. They look great on paper, but how they'll actually be implemented remains to be seen, and that's what we'll all be watching very carefully in the short term.
You talked about validity and confidence in validity as one of the considerations for companies thinking of staying in the UPC system. What kinds of things could give an organisation some confidence in that validity? So is an opposition enough, or would you want some sort of previous court testing? How broad does the prior art search need to be? And does that change by industry? And I ask because in my former role, I looked at this back in 2015 and was looking at those patents which had been opposed as being more of interest to third parties, and so potentially thinking about opting those out, whereas the ones that hadn't been opposed, I was thinking about leaving those in, just from a budget management perspective, because obviously there's a cost associated with opting out. Plus, in that industry, really one sort of action in one jurisdiction was enough to change the way that whichever the defendant party would manufacture. So nobody really wanted to have a split market in terms of different types of products in different jurisdictions. Are you seeing that kind of sort of decision making, or are you seeing, there's been an opposition, the patent's been strengthened, put it in and see what happens?
I think that's a really interesting perspective from the private practice side and the litigation side. I think the general view is that a patent that has gone through opposition and has survived in one form or another is battle hardened and has had its validity tested. Similarly, for a patent or a local designation that's gone through national proceedings in a reliable jurisdiction, the UK, for example, Germany or the Netherlands or one of the other European courts, the regulatory patent litigation, again, where validity has been tested, well, then that's a real plus from a validity perspective. So from a litigation perspective, those assets, I would think, would be attractive for leaving in the UPC, setting aside any other commercial reasons for opting out. And of course, cost is a very important factor. The on-the-ground reality is that opting out, these processes all cost money. And we're fortunate on the litigation side to not be so involved in that side of the decision making, but certainly it'll be a factor that the patentees will be thinking about.
Yeah, I think from the corporate side, there's budget and there's strategic considerations at play. And when I was in-house and talking to the commercial leads, then litigation wasn't really high on their list of priorities. Selling products was. So anywhere we could mitigate the litigation risk, and specifically, I think opposed patents, yes, I agree. They've had some testing. They're going to be a little bit more battle hardened, but if those are going to be targets for revocation, then the litigation risk for an in-house person may be a little bit higher.
I think that's fair.
The consideration for me was how to mitigate risk, and where we had patents which had been opposed, it's more likely that a third party may try to have another go and centrally have those revoked, even if they hadn't tried on a piecemeal basis, which would then mean that there was a higher risk that we would be drawn into litigation. Whereas if we opted out for a period, it could maintain sort of a bit of the status quo. And then if we wanted to enforce, we could go back in.
That's fascinating. I hadn't thought about it from that perspective, that it gives a potential defendant a second bite of the cherry, as well. Of course it does. And the same is true currently outside of the UPC. You can always go and seek to revoke a patent or a national designation and then roll out a positive decision. But I think the general prevailing view that a patent that survives opposition will probably persist, that it'll be harder to revoke. And I expect the UPC, at least to start off with, will be relatively deferential to the EPO in the way that the national courts in Europe currently are. There are varying degrees of deference, of course, but I would expect that to continue. But yes, I mean, that's a fair point. I mean, there is a second bite there, and the risks of a revocation at the UPC is that the patent will be revoked in all UPC territories, and so that does up the ante somewhat. I think what helpfully counterbalances that, of course, is the fact that there are key jurisdictions not in the UPC, and so you still have your EP designations there, the UK and Spain being the obvious examples. There are others. Turkey, for example, also isn't in the UPC.
I think there's, outside of the UK and Spain and Turkey, there's a long list of countries which signed the UPC agreement but have not ratified, so won't be in on day one. So Ireland is one. How do you think the kind of division of litigation will work between the UPC and those that are not in the system?
You're quite right. I mean, there are a number of countries that signed up and haven't yet ratified. I think at the moment on day one, the UPC will cover a territory with a combined population of 300 million, and that'll go up to 327 million once all of the other countries that have signed up but haven't yet ratified finally do. I'm not sure how the litigation will be divvied up, as it were, between those in the system and those not yet in the system, but likely to be. I think it's fair to say that jurisdictions like Ireland, and I think Latvia is another country that is signed up but not yet ratified, they don't really see much in the way of regular patent litigation. I think more interesting will be how the UK and Spain interplay with UPC actions, and I can see there being real merit and advantage in having parallel actions in the UPC and in certainly the UK to not just play off the courts, but also to help inform decision making in the UPC. The UK, for example, has a disclosure regime and longer trials, extensive cross-examination, and the output of the UK trial could still be quite useful in what is a very accelerated process in the UPC.
Thanks, Raj. That was really interesting. I'm going to go back to what you said 2 points ago, just on the sort of being deferential to the EPO. So question is, in the new court, you mentioned that the judges are likely to be deferential to the EPO in terms of looking at what's been held in opposition and how the patent has been approached. Do you think that the court will be claimant friendly? Will it be a new Western District of Texas in Europe? Because the timetable is quite accelerated, which traditionally is a claimant advantage. I have experienced 9-month trial schedules from the defendant side, and I can genuinely say it's terrible in the US where there is disclosure. So how do you see the sort of balance between claimant and defendant being in the new court?
I think the UPC is definitely being marketed as a patentee claimant friendly jurisdiction. There are two aspects to it. Is it claimant friendly? Yes. Does the claimant have an advantage in starting UPC action? In the first instance, yes, in the same way that a claimant would in any action. You have all the time in the world, as it were, to put together your filing, and then the clock starts ticking once you've issued, and then the pressure starts. But I think the UPC also, at least to start off with, will be quite patentee friendly, because the UPC wants to encourage patentees to use the court in the process. And certainly that chimes with comments made by judges in the UPC. I think Judge Rajvinder spoke recently at a conference in London where he promoted the benefits and the merits of litigating the UPC to patentees. And there are clear advantages. The population size makes it a compelling choice for patent holders that otherwise would litigate in the US, which is a popular forum certainly for NPE actions. And the combined population of the UPC makes it a compelling alternative to the US in terms of market size and GDP and the scope for damages, and also the threat of injunctive relief.
You mentioned Grabinski giving a talk recently, and obviously he's the president of the appeal board of the UPC. Do you think that the court will have quite a German flavour? I've seen the list of judges and there are a number. And I think by that I'm referring to, do we think that the judges are going to use their sort of national upbringing to bifurcate, which I know is optional in the UPC?
That is the million-dollar question. I think there is certainly a strong German influence in the UPC and the rules of procedure and assessment of the course. And that makes a lot of sense given the sheer volume of patent litigation that takes place in Germany. And for similar reasons, there is a strong UK influence to the rules. The expert testimony and relatively limited disclosure obligations all draw in from the UK system. It's hard to take personalities and familiarity out of the UPC, I think. I expect we will see a degree of German procedural influence in how the UPC operates in the short term. Part of that will depend on where the first UPC actions are brought. Of course, claimants can choose between central, local, regional divisions. And I think we can probably expect to see quite a few of the initial cases brought in Germany in the German local divisions. And so we'll have German judges sitting on the panel, and no doubt that'll influence the way case management decisions and actions are administered in the first instance. I hope that over time there will be a harmonisation approach, but that will take some time. And it's not just the German influence, of course. Other local judges will bring local flavours into the UPC and into their case management decisions, and also substantive decisions on infringement and validity.
We talked about the judges. What about the advocates? So obviously UK solicitors are not able to represent clients in front of the new court, but European qualified patent attorneys can. Do you think that we'll see many cases led by patent attorneys? They obviously have experience from opposition and representing clients there, but less so in court. And do you think that that will then lead to a more sort of technical flavour to the UPC?
I think there are real opportunities for patent attorneys to get involved in the UPC. As you say, they have rights of audiences where they can be appointed representatives. And the front-loaded nature of the UPC makes it quite amenable to the nature of prosecution work. And for similar reasons, German attorneys will, I expect, quite appreciate the written procedure of the UPC timeline. I think where things get more interesting is when you get to the oral procedure at the end, and that's where more seasoned litigators perhaps have an advantage. And it'll be interesting to see how the two play off each other. We already have a view on this from Germany, where we're used to this approach, but the UPC timeline is, I think, fair to say, quite accelerated even compared to Germany, and the way that the process is currently carved up into these three phases, the written, interim and oral procedures, adds a slightly stricter sequence to a first instance trial than we see in Germany, where different divisions, different courts have their own approach to case management. I think there's also a role for UK lawyers, irrespective of the appointed representative status. The UPC is another forum for patent litigation, in addition to litigation in other courts in Europe, in states that are not part of the UPC, like, for example, the UK. UK law firms have always played a role in coordinating complex multi-jurisdictional litigations, and I think we'll continue to do so. And I expect that we will play an active role in coordinating and assisting on UPC matters.
Just picking up on that point, and the UK not being in the UPC could be a strategic advantage for claimants or patentees when they're thinking about their strategy, coming to a court system where the predictability of outcomes is maybe a little bit more certain, and where the timelines are still relatively quick. And there's also a disincentive, again, for bringing vexatious litigation because of our adverse party cost regime. Do you think that the UK may see an increase in cases because of the predictability? I know litigation is a big investment for corporations to make. The fees and costs are not cheap. And so if they're going to take that decision, do you think that going in a forum that is more known and more predictable could be one of the reasons why the UK remains an attractive jurisdiction?
Absolutely. I think the UK will continue to be an important jurisdiction for patent litigation for precisely the reasons that you just said. It is a tried and tested jurisdiction. We're well respected, both in Europe and internationally. Our patents court has a very good panel of technically qualified judges and has had for a while. And we have a system that the patentees are familiar with, particularly so US clients with European patents. The UK system is much closer to the US approach for obvious reasons than it is to the civil law approach in continental Europe. And so what will be in the UPC? There are perhaps similarities in terms of the timeline between the UPC and the ITC, for example, in the US. But the approach to litigating substantive issues is still very much more aligned with the UK common law approach. The extensive cross-examination of experts at patents trial in the UK will last anywhere between 3 days to weeks, as you know. And a key component of that is the cross-examination of experts. Contrast that to the UPC, where it's expected or anticipated that the oral procedure will be over in a day. Clearly, there isn't time in that object to cross-examine to the same extent that one can in a UK trial or indeed in the US. So I think for certain clients, the UK will still be a very important jurisdiction, perhaps as a precursor to UPC action or in parallel with it and lockstep with it. And also, of course, disclosure is another great advantage of the UK system, where a patentee needs more information on infringement or on what a potential defendant is actually doing. Well, then, the streamlined disclosure regime in the UK as compared to the US, PPDs, might be quite beneficial. And of course, cost recovery, as you pointed out, is also a real benefit of the UK system. Of course, the UPC also has a cost recovery regime. It is a hybrid approach between the UK and German systems with a fixed fee component and then a variable component as well. But I think it's fair to say that the way cost shifting works in the UK is an incredibly useful tool in keeping parties honest and also efficient and litigation streamlined.
So thinking about the UK system and multi-jurisdictional campaigns, do you think that actually the fact that there is a disclosure regime or a product and process description and extensive cross-examination could mean that the UK action could come earlier than a UPC action to gather some of the evidence to prepare a broader action if that was part of the strategy for a particular organisation?
I think that's certainly an option and one that might be explored. Of course, one can't automatically use a PPD or information disclosed in a PPD in proceedings elsewhere, and so that has to be factored in. But even today, outside the UPC, it is typical to see UK and German actions run in parallel. And although disclosure in the UK can't be used in Germany, it is a useful tool to keep parties honest, to make sure that positions are consistent across the jurisdictions. And I can see that being usefully deployed as between the UK and the UPC. There is a limited disclosure regime built into the UPC rules. And so we may see that being used as well. And it'll be interesting to see to what extent that is used and disclosure is granted or ordered, and how that interplays with the utility of extraterritorial disclosure mechanisms like the UK and PPDs, and perhaps obtaining the permission of the court to use it elsewhere, like in UPC action. Or, of course, 1782s in the US, which result in quite extensive disclosure if they're awarded. But the counter to that is, of course, you then have to spend the resources in working through it.
You mentioned NPEs or non-practicing entities and the high claim rate for NPEs in the US. I think one of the big concerns with the broadening market of the UPC and potentially larger damages, that the UPC could become a very attractive forum for more MPE cases. What are you seeing on that front, and what's your view?
I think there's a lot of interest in the UPC amongst MPEs. I was at a conference recently in California that had a lot of tech clients and MPs in the technology space, and there was a great deal of interest in how litigation in the UPC might play out and strategic options. I think the key driver is the market size. Until now, the US has been the most efficient place to enforce a patent portfolio to get a damages award. Of course, treble damages in the US for willful infringement are also a helpful incentive. Of course, the UPC will not have a punitive damages regime. It will just be compensatory in nature. But still, the ability to enforce a patent centrally in Europe over a population of 300 million, GDP of around 12 trillion, the potential for a large damages award becomes quite real, and it'll be much cheaper than enforcing piecemeal in national courts, which is the only way to do it today. And so I think MPs will look very carefully at the UPC, but given their familiarity with the US system, I think there will be some trepidation in jumping straight into what will be effectively a relatively alien court process. And I think that is where, again, the UK as a bridging jurisdiction comes into play. And dare I say, UK Counsel, UK lawyers can assist in helping bridge that knowledge gap and managing litigation in a system that we are more familiar with, given our experience of coordinating actions in Germany and elsewhere in Europe.
Do you think the commentary around potentially increasing MPE activity in Europe is maybe a little bit too excited? Do you think MPEs will be more cautious around some of the procedural elements in the UPC that they're less familiar with? For example, adverse party costs, which don't exist in the US, and availability of patents which have been validated broadly enough within the UPC countries to really move the needle on damages?
I think those are two very good points. As you say, given the focus on the US, adverse party costs, cost shifting, it is a real unknown for MPs that aren't familiar with Europe. And certainly it's something that is often mentioned by MPs in my discussions with them when discussing the UK as a forum. It's more an unknown for them than it is a disincentive to litigation. I think there just isn't really an understanding of how that works, or an appreciation that the cost of litigating in the UK today and the cost of litigating the UPC will be considerably less than your typical US patent litigation. So I think there is some work to be done in educating and helping potential court users on these issues and the nuances of the differences between the regimes. And of course, you're quite right that the scope of coverage, at least in the short term, is going to be an important factor for MPs to consider. It depends on also the sector that the MP operates in, as we discussed previously. Also, an important factor will be the sector the MP operates in. In the tech sector, for example, patents are validated only in a few key jurisdictions. And so even if an EP validated in, say, Germany, the UK, France, the Netherlands, is left in the system, and so the Dutch, German, and French designations become effectively a UP who have unitary protection.
So we've talked about damages and now injunctions. Obviously, in the US, getting an injunction is incredibly difficult now. Do you think that the ability to get an injunction in the UPC could be a very attractive factor for a UPC litigation or a UK litigation?
Absolutely. I think the real threat of an injunction, the fact that it will be, at least on the face of it, easier to obtain in the UPC than it is in the US, is a real driver for MP interest in the UPC as a litigation forum. The general business model of an NPE is to use a threatened injunction to leverage a settlement. No one really wants to go into a complicated and protracted damages inquiry. And so I think the injunction threat is a real plus of the system here. And as you quite rightly point out, in the US, it is very difficult to get an injunction in the district courts. Of course, the ICC is used as a forum to obtain an injunction. But again, even there are hurdles that the parties have to jump over to get that. And not everyone is entitled to use the ICC process. And so, yes, absolutely, I see that being a real driver for that interest.
So in the UK, damages are bifurcated from liability in terms of procedure, whereas in the US, it's an all-in-one. The advantage of the bifurcated procedure is that there's an opportunity for a commercial agreement to be reached. What's the UPC going to look like?
Well, interestingly, the UPC allows for both. It allows for damages to be rolled into the substantive validity action and for it all to be addressed at the end. But it also allows for the damages inquiry to be hived off to a separate trial, a separate process, and there's also scope for it to be referred to arbitration. I think practically, given the compressed timeline and the one-day trial, it just isn't realistic to have a comprehensive damages inquiry at the same time and the same process as the liability trial. And so I fully expect that the damages inquiries will be punted off to a second hearing or a second process.
I think people have said it's double the cost of a German action and plus adverse party costs. Do we think that that's going to make it an attractive place to go? So someone told me, I'll ask this properly in a minute, someone told me a UPC action will be 2 times the cost, 10 times the benefit of a German local action, whereas a US would be 10 times the cost but maybe more than 10 times the value of a German action. I guess it's forum shopping and how people just trying to work out, because from our side, the things we're interested in is how predictable is the court, how much is it going to cost, what quality of patents are going to go there, because from an investment point of view, are we going to want to invest in any of these cases? Because if people are just chucking in their weak patents to see how it goes, then that's a problem. What are the damages going to look like? Because if the patent family hasn't been validated widely enough, it's going to be more expensive and no different than going nationally.
Yes.
So those are the kind of things that we're thinking about when we think about UPC.
Yeah.
And I think we've kind of covered most of them.
In terms of costs of a typical UPC action, I think it'll be more in line with your typical UK action than a German action. For example, the procedure is a little more complex than what we see in Germany at present, and the cost shifting regime also needs to be factored in. We do that already in the UK in advising clients on the cost of an action, and that's something that will need to be considered in the UPC as well. In terms of damages awards, the scope of protection is going to be very important in the short term, in the transitional period, where EPs with varying coverage will be effectively converted into UPs in the sense that they'll have unitary protection, but only in those countries in which they're validated. Of course, as we move into the system and as new patents are granted with unitary effect from the outset, they will have coverage in all of the countries participating in the UPC system. And so the analysis from a strategic perspective will change as we move through the process.
So finishing up, Raj, do you think that the UPC is really going to be the biggest sea change ever in European patent litigation?
So, of course, it's been long expected. We've been talking about the UPC for decades now. So there will be a sigh of relief when it finally starts. I think the UPC is a seismic shift in patent litigation in Europe, and it will certainly change the way court users, patentees, and practitioners alike approach European patent litigation for generations to come.
What will the system have? Is it just for filing, or will it be like PACER? I guess it depends what you can see. Is it going to be just for filing, or is it going to be somewhere you can actually see case documents?
I think there will be a component of the case management system that is publicly accessible without authentication credentials. And so by which I mean you'd be able to set up an account and access it like you can with Pacer, for example, or with Fastnet, indeed, for accessing, or the EPO register for accessing opposition filings. But in order to actually make filings in the UPC, representatives need to have strong authentication credentials, which means for the moment that they need to have a physical authentication security token, a smart card, or some other authentication device, I think a USB stick, that you plug into your computer and use that in combination with a certificate installed on your computer to access the site. And suffice to say, it is quite a complicated process. And I think that's one of the main reasons why the launch of the UPC has been delayed, to enable those IT issues to be somewhat streamlined. And I hope that the security system might be somewhat simplified and brought up to date, so that other authentication means can be used to get on. But certainly that is a short-term issue that is currently vexing a lot of people interested in using the system. So I have a question for you from a funder's perspective. How are you approaching the UPC, and how do you think you will assess whether or not to fund a matter in the UPC? And following on from that, the interplay between the UPC and other jurisdictions in Europe, like the UK or Spain, in the context of a packaged funding proposal.
I think, in summary, we're watching with interest. We've looked at a couple of opportunities, and I think the UPC does give an opportunity to increase the damages available if the patent has been validated broadly enough. My view, and this goes back to some of the comments that you made around the different sectors and how broadly patents are validated in the EU, is that quite a lot of the patent cases that we see are in the tech sector, where maybe validation hasn't been as wide. And countries which are standard countries for validation are the UK, which is not in Spain. So you're really looking still at Germany, Netherlands, France, Italy. Is that broad enough to really increase damages significantly? Obviously, Netherlands being a port city for a lot of imports, you're still going to have that coverage from an injunction point of view, which will impact more broadly. So I think the question for us is the economics. Does the economics work? The cost of bringing a case, more than Germany, probably about the same as the UK, plus an element of adverse party costs. So that could mean an indemnity from the funder or insurance has to be offset against the damages. So if the damages are large enough and it economically makes sense, then that's interesting. Most importantly for us, though, is the merits. It's got to win. So how do we assess that in the court system, which is new, where the judges are applying different rules, maybe with a blend of flavour from their international colleagues? How are we going to map out our risk in terms of each of the cases? What is settlement going to look like in a really accelerated proceeding? Is there going to be a very low likelihood of settlement of UPC cases after the case is issued? These are the questions which we're grappling with at the moment, but I think it's an interesting jurisdiction. Picking up on the interplay of the UPC and other jurisdictions in a multi-jurisdictional campaign, again, I think the same thought process applies, in that how many jurisdictions now in the transitional period will count in the UPC. So how widely has that patent been validated, versus picking some individual jurisdictions and then knowing the predictability of how cases will move through those jurisdictions, and potentially how sort of judges see different issues also comes into play. So I think, to conclude, we're watching with interest, but I think, like everyone else, we're keen for things to get going and to see how the first cases move through.